รายการต่อไปนี้เป็นรายการทั่วไปสามารถรับชมได้ทุกวัย
สนับสนุนโดย AIS ใช้ชีวิตได้มากกว่าใหม่ MG3 ชีวิตไหนสไตล์ไหนก็ฟันยกระดับความแรงและทนด้วย FB Premium Go SMF FB แบตเตอรี่ไฟดีไม่มีทรยศนุสา My Ozone คิดให้ชีวิตสมบูรณ์แบบ
An example closer home, we have this haze issue in Southeast Asia.
Oh, yes.
Forests are burned in Indonesia. And we get this haze, this smog all over Malaysia, Singapore, southern Thailand and all this.
And Philippines.
And the Philippines. And I understand Singapore has enacted laws that say we will punish companies that are somehow related to the burning of forests in Indonesia.
That are listed in Singapore.
That are listed in Singapore. And I was wondering how one country's law can apply to activities in another country in this case.
So in that case, it is the law is applied to the company that is incorporated in Singapore.
In Singapore.
Only the incorporated in Singapore?
That's right.
But
Malaysia has the same law. They penalize the company incorporated in Malaysia, but have operation elsewhere. And if it can be proved that such operation create like the haze effect on health, pollution, on countries, especially the countries that the company is registered.
One would
they
assume
have a right to penalize.
But one would assume
the Malaysian, country A cannot penalize the company in country incorporated in country B.
That is a limitation of the domestic laws. One would assume that international law then can cover this kind of international incidents.
But you see, we touch on this issue as well because there's international law regulating the use of water, for example.
Yes.
One country, we call the riparian states, using the water causing damages to another country down the river, then certain claim can be issued. There's a case decided by the International Court as well, where the pollution from one country, affecting another country.
In Europe, they have a long-distance air pollution convention that acid rain covers several countries.
Yes.
So these countries come together and addressing these issues. And that's international law, that you have a treaty and irrelevant countries participate and address the root cause. This is air pollution. For water, for instance, River Rhine runs several countries, and then through Netherlands down to the North Sea. And throughout, then the upstream pollute water, then the downstream suffer, right?
Right.
The same situation. Then they have the convention to address the issue and about water pollution.
They also have punitive measures.
It's really preventive and remedy issues, but it depends on the terms that the parties agree. But the example you gave about Singapore or
Indonesia, Singapore,
Malaysia,
the Philippines.
It's really the internal national law have tried to have extraterritorial effect. But I won't call it the international law as such. I think it is a matter within ASEAN country.
Yes.
These countries have to sit
So
down
I think it's
and
a
talk
challenge
to
for
see.
ASEAN.
Yes.
It's a challenge for ASEAN.
It's,
whether we can develop
it's another really
regional
international
convention.
law in the true sense of the term.
That's right.
It's your own internal problem. You have to solve it.
I think what you say is right as a matter of direction. The international law is moving in that direction. If you say that as a matter of reality at present, that is already the situation. Unfortunately, that is not. But we are moving in that direction, and in order to move that direction more positively and more rapidly, you need international cooperation. And that is the key. as Dr. Aziz was emphasizing, in the essence of completing the regulatory framework that I talked about of the global community as a whole, you have to have the international cooperation through different states, including not just the government, but also practicing lawyers and civil society, the members who are acting in the same direction, and to move the trend in that direction. So I think as a matter of the direction in which we are moving, I think you're right. On the other hand, if you say that this is already the reality, perhaps it isn't.
No, because it's the ASEAN style. When they sit down, they will not discuss laws or punishment. They will say, let's cooperate. And maybe we should meet more regularly. Maybe we should share information. But they already have the information. They know what companies are involved in that. But is it possible to have an ASEAN court, that can beat out punishment to people who create climate problems for the whole region? Does international law play a role here?
Well, somebody will raise issue, but maybe in front of the two judges, we cannot raise this issue. But somebody will raise issue whether we can file the case in the international court based on international torts, for example. The file in the peatlands in Indonesia, the hotspot is, like I said this morning, 10 times the size of Singapore. It covers half of Malaysia, the whole Singapore, 6 provinces in southern Thailand, now this time all the way to the Philippines, and cover a large area in Indonesia. Now, what is a remedial measure? What is a court case that can be
instituted? And the health hazard is still has not been estimated, has not been evaluated. It is very serious. And it cannot be measured in terms of money alone. It is the livelihood of the whole community. And that has nothing to do with the border anymore, because the smoke, there's no border. You just come wherever the wind blows. Anyway, you want to add something?
That's Judge Owada's point. The international cooperation, dialogue, consultation should take place first. I agree with him.
Now, another interesting issue is the South China Sea, also an international issue now. The Philippines has filed a case against China in the international Court of Arbitration. Court of Arbitration, yes. Is that?
The International Tribunal for Law of the Sea.
Tribunal, yes. Does that come under international law?
It's
Tribunal. And China say we don't accept the role of the tribunal, international tribunal. The tribunal?
Jurisdiction.
We don't accept the jurisdiction. So how can international law play a role in settling this issue in South China Sea?
When China says it does not accept jurisdiction, is it still applying international law?
It still applies.
Because that's based on the international law it interpreters. Because jurisdiction matter is really important. When you come to certain jurisdiction, the first question you have to think whether either the court or tribunal has jurisdiction. But as a judge, I said I can't say anything at this stage about the matter.
But Mr. Deshai, the law of the sea itself, which is international law,
the law of the sea,
convention, also allows for parties which has overlapping claims to agree among themselves, for any functional economic cooperation. The example between Thailand and Malaysia and so many other examples would follow this particular principle. We have overlapping claim in the Gulf of Thailand, between Thailand and Malaysia. In 1979, over 30 years ago, we decided to cooperate and work on the joint development area of oil and gas without prejudice to the respective claims in the Gulf of Thailand. And the functional cooperation, the joint development area has been working well. It's been over 30 years. We negotiated the sea boundary delimitation every year. Some with certain success, some year without success. But we continue to do that. But there's no misunderstanding, there's no miscalculation, there's no clash in the Gulf of Thailand because of this alternative arrangement, the commercial arrangement. So my personal view is that the claimant states of the South China Sea should be patient, should find alternative model permitted under international law to engage in the positive dialogue on the possibility of commercial arrangement, joint scientific research, functional cooperation in the South China Sea with the support of the non-claimant states of ASEAN. I think that's probably the way forward, and this is the role of international law as well.
Yeah, I just want to jump into Dr. Surakert's comments because I think in issues about these disputed areas, there are two aspects to it. I think there's a legal aspect to it and the sovereignty issue, but there's also the economic aspect, the more practical aspect to it. And I think necessarily the sovereignty issues are going to be much more complex, more difficult, and may take generations before they're ever resolved, if they're ever resolved. But the economic and the practical aspects of it can already be addressed even now. You know, even as the Philippines, and I should be careful as I am from the Philippines, even as the Philippines has taken on the legal actions that they have taken, it should not stop both states from continuing a conversation on the more practical, more economic aspects of the
just like the
disputed
joint development
areas, as has been mentioned.
Thailand, Malaysia.
And that may in time also help address eventually the sovereignty issues that are being contested. And I think Singapore and Malaysia also had that particular situation in the islands, you know, between Malaysia and Singapore.
Well, I think last year Myanmar and Bangladesh also agreed on a joint development area of oil and gas in the Andaman Sea. And there are examples elsewhere in Africa, in Europe, and so on and so forth. The South China Sea may be a little bit more difficult because it involves more than two countries, Malaysia, Brunei, and Vietnam. But that's should not be beyond our ability to be creative. It may be several bilateral arrangements, or it may be a big challenge, 5 countries working together, how resources can be shared in the future. Of course, it will not happen overnight, but I think we can leave the issue of sovereignty there, and then let's look at how we can discuss commercial arrangement. And we believe that the commercial arrangement is less confrontational. It will stir less of the domestic patriotic emotion in each country, and I think that's the way forward. So I hope that soon there will be a convergence of views that this is the way the international law can be helpful in bringing parties to the claims in the South China Sea together for something constructive and less confrontational.
But South China's
for international law, the basic thing is it's not something you have dispute. The key is to settle the dispute in a peaceful way. This is the key. Secondly, the principle of cooperation is really the foundation. And for neighboring countries, for China, the Philippines, we are good neighbors. And when we are neighbors, doesn't mean we don't have dispute. It's only natural for two brothers that can fight, you know? But the things that let's sit down, talk, consult, see what kind of a measure we can really settle a problem. I think President just gave a very good idea. We can move forward, talk about, starting from the easy part and then gradually move on. As we move on, we build up mutual trust and benefit from the cooperation. I feel I'm quite confident we would have to find, using Asia wisdom, find the way.
ช่วงหน้า
How does sustainable development get linked up with international law?
สนับสนุนโดย AIS ใช้ชีวิตได้มากกว่า Rockwood เชื่อว่าบรรยากาศของออฟฟิศที่ดีมีผลต่อการดึงศักยภาพที่ซ่อนอยู่ออกมา JSP City สุขุมวิทแพร่กษาทาวน์โฮม4 ห้องนอนเริ่ม 1.64 ล้าน by JSP Property
I think Deng Xiaoping was very wise when he said that I don't think our generation has the wisdom to solve this problem. So let's postpone it to the next generation. Meanwhile, we can work on economic cooperation.
Let's look at issues that is workable.
Right?
Win-win, I think.
He said it years ago. I think you remember that.
He said that we should shelve the sovereignty issue.
Something like that. That
may not be resolved
let's
in our
admit that.
generation.
Spend it.
That's right.
But I think China Sea is not only an economic issue or even a legal issue. It has become a geopolitical issue. So it's getting too complicated for international law.
International law never works in vacuum. It's always mixed. You know, have the background, political, geopolitical, economic. You know, so for international lawyers, it's always beneficiary to talk to politicians, to economists, to bankers, you know, to journalists, you know. Then we can benefit from your perspective, your wisdom.
Judge Owada, before you became a judge, you were very interested in sustainable development.
Yes.
How does sustainable development get linked up with international law?
That's a good question, and I was very much impressed by the remark made by Her Royal Highness this morning in her opening keynote address. She emphasized the importance of sustainable development goals in the contemporary setting, and she did it in the context of the international legal framework of the present-day world. She was not really talking about economic issues. She was really talking about the social or societal issues of the global community. And I think that's most important because, as we have been discussing, international law is a overarching regulatory framework. Regulatory, I do not mean legalistic in general, but the network of norms which control the activities of human beings while promoting the freedom of activities of human beings, because society, after all, it exists for the sake of, for the benefit of human beings, and in that sense, I think the basic factor that we have to think about is how you improve the social conditions of the global community as a whole, rather than as part of the globe, but the globe as a whole. And the sustainable development goals, or the issue of development, really is the essence of this whole program. You remember that during the Cold War period, the issue of development was identified as the economic development, which was translated in terms of 0.36% of the GNP or 0.70% of the GNP. Now, that to my mind is nonsense, because what matters is not really the input that you put in terms of the money, financial money that put into a particular society or particular country. What really matters is how much you achieve as a result, how you succeed in making the society mature, more secure, more livable to human beings.
Yes.
And with the demise of the Cold War, the moment has arrived. I'll give you one interesting example. When I was in the government of Japan, I was in the position of the Sherpa dealing with the G7 summit. And Japan proposed that now is the time, this was the early 90s, after the demise of the Cold War situation, Japan proposed to the partners in G7, now is the time that we should think much more seriously and much more intently on the question of genuine development, not the strategic development assistance that we had been talking about during the Cold War period. What really matters is how you improve the societal conditions of the whole world, including the developing countries, but not limited to the assistance to the developing countries, but the problem of the social problem of the community as a whole. For that, you have to cooperate. You have to think about this problem as a common problem to everyone. The reaction at that time, the reaction of the other members of the G7 was totally negative.
Totally negative.
Totally negative because they thought they had just got rid of the yoke of the strategic assistance which they were compelled to do in the East-West confrontation.
Yes.
And in other words, the expression North-South problem is juxtaposed to the East-West confrontation. And therefore, East was South and North was West.
Right.
And that's a very, very misleading oversimplification of the situation. What really matters was the fate of the whole globe. And international law tries to cover it from the regulatory side of the picture. But the substantive side of the picture has to be covered primarily as the issue of development in the sense of social development of the whole community. And in that sense, I think these two issues are closely linked. And I think the issue of sustainable development is an extremely important or essential ingredient of the international legal framework that international law is trying to promote.
Dr. Surakiat, talking about sustainable development, our King's initiative is about self-sufficiency, also sustainable development.
And I think there's a lot of room for the Asian countries, particularly East Asian countries, Southeast Asian countries, to play a much more proactive role in this. Because this part of the world, comparatively speaking, has been immune from the impact of East-West confrontation during the Cold War period. If you compare it with Africa, for example. Africa was really became prisoner of East-West confrontation, whereas Southeast Asia was trying to focus on their nation building, on their local development, on the society building, and so forth. And I think they have the advantage. They have a common experience to share with our partners in different parts of the world. And I think that I would like to emphasize that it's very important for the countries in the ASEAN in particular, but not only in ASEAN, but in this particular region of the world, to try to be much more proactive in this area of development, particularly in promoting the new Sustainable Development Goals, SDG, to promote it, to make it the common normative values in which the development should be achieved.
But how can we link international law with sustainable development from the Thai point of view?
Well, right now the leaders met in the United Nations in October. Leaders of all countries have agreed on the Sustainable Development Goal, SDG. There are 17 goals in there. Access to justice and rule of law is a part of it. There's a treatment, of children, of women, access to water, climate, good climate environment issue, and so on and so forth, including how the development can be sustainable. So countries would have to work together, although this is not the international law that is legally binding. But it is something that I always refer to it as soft law. It's the will of the international community that this is something that we have to work together. But under this Sustainable Development Goal, there are so many international conventions, treaties, and domestic laws relating to some of these 17 development goals. And I think His Majesty the King philosophy of sufficiency economy that he initiated 40-something years ago, which emphasized on the moderation, mindfulness of things you are doing, appropriateness, not to overspend, not to underspend, not to overinvest, not to underinvest in good times and bad times, having immunity in your life that can be applied to a person, to a company, to a country. So I think his philosophy of sufficiency economy is very much in line with the Sustainable Development Goal adopted recently at the United Nations. And many countries now have sent their representatives. In fact, there was a big congress the day before yesterday, where experts from all over the countries gathered here And they also went to the northern part of Thailand to look at the application of the philosophy of sufficiency economy, how moderation, reasonableness, mindfulness in things we are doing, not to overspend, underspend, how that can be applied to the rural development, to the urban development, to the operation of the corporation. In the modern economic world, it's really a risk management. If you talk about risk management, I think that's what international business will understand. But that is very much based on his philosophy, and I think it's very much in line with the Sustainable Development Goal.
Sustainable development international law has gone through a process of development. Originally, it was the idea of environmental protection. So from 1972 Stockholm Conference on Environment till 1992, the second International Conference on Environment and Development. The states, international community have a better idea about environmental protection vis-a-vis economic development. So that's the idea sustainable development started to take off. Now, from relations between environment and economic development, now we realize not only that two elements, but you have to add social development. But I think one thing for ASEAN, I appreciate very much. ASEAN, when it became an integrated regional, sub-regional organization, you set up three pillars. One is a political security pillar, second is economic development pillar, the third one is a social cultural pillar. If you put the three pillars together, that really reflects the idea of sustainable development. So this is a very good example. When you talk about international law, sustainable development, now you have a full-fledged concept.
So in conclusion, Judge Owada, international law is everybody's concern.
It is. It should be, and it is. One problem with international law is that many people feel that this belongs to a different world.
Right.
Nothing to do with me.
Right.
But as someone was referring this afternoon, if you want to travel from Japan to Thailand, or from Thailand to the Philippines, you cannot do that without the regulatory framework of international law.
Right.
That's impossible. It's not like moving from Bangkok to Chiang Mai.
No.
So international law is really permeating into your daily life. And you have to think about it as an advantage, as a benefit for your own life, to improve your life and to expand the scope of your activities. And that is the spirit in which international law should be looked at by the people in the street.
Thank you very much. Thank you, everyone.
Thank you.
Sorry we don't have more time.
Thank you.
Thank you.
Thank you.